Article 125. Delay the delivery of detained person to the proper judicial authorities. The penalty provided in the next preceding article shall be imposed upon the public officer or employee who shall detain any person for some illegal ground and shall fail to deliver such person to the proper judicial authority within the period of 12 hours for crime or offense punishable by light penalties, or their equivalent 18 hours for crimes or offenses punishable by correctional penalties, or their equivalent 36 hours of crimes or offense punishable by afflictive or capital penalties or equivalent. In every case, the person detained shall be informed of the cause of the detention and shall be allowed upon his request to communicate with comfort to any time with his attorney or counsel. What are the elements of Article 125? Elements: that the offender is a public officer or employee, na ang may sala isang opisyal o publiko empleyado. Number 2, that he has detained a person for some legal ground, na ang kinulong niya ay illegal, na ang kinulong niya ay isang tao na legal sa legal na dahilan. That he fails to deliver such person to the proper judicial authorities within 12 hours for crimes of offense punishable by light penalties or their equivalent, or letter B, 18 hours for crimes of or offense punishable by correctional penalties, or their equivalent, or 36 hours for crimes of offense punishable by afflictive or capital penalties, or their equivalent. Na ang nabigo niyang mahibla sa korte ang tao sa loob ng 12 oras para sa krimen na may parusang light penalties. Ang katumbas nito, letter B, 18 oras para sa krimen na may parusang correctional penalties sa mga katumbas nito. Letter C, 36 oras para sa krimen na may kaparusang afflictive or capital penalties sa mga katumbas nito. Number 2, what are the crimes if the offender is a private person? If the offender is a private person, the case is illegal detention. Kung ang may sala ay pribadong tao, ang krimen ay illegal detention. What does the phrase shall be detained any person for some legal ground mean? Under Article 125, the public officer or employee has detained the offender party for some legal ground. The detention is legal in the beginning because the person detained was arrested under any of the circumstances where arrest without warrant is authorized by law. The detention becomes illegal after a certain period of time because of offended party is not delivered to the proper judicial authority within the period of specified by Article 125. Sa ilalim ng Article 125, ang opisyal publiko o empleyado ay nagkulong ng naagrabyadong tao sa legal na kadahilanan. Ang pagkulong ay legal sa simula. Dahil sa taong ikunulong ay hinuli sa ilalim ng alinman sa mga pangyayari na kung saan ang paghuli ay na walang warrant ay pinahintulutan ng batas. Ang pagkulong ay magiging illegal pagkatapos ng ilang oras dahil sa naagrabyadong tao ay hindi nasambahan ng kaso sa loob ng panahon na tinakda ng Article 125. Does Article 125 apply when the arrest is by virtue of warrant of arrest? Under Article 128 applies only when the arrest made without warrant of arrest, but the arrest must be lawful. Mag-apply lamang ang Article 125 kung ang paghuli ay ginawa na walang mandato o di aresto. Para sa paghuli ay dapat na ayon sa batas. If the arrest is made with a warrant of arrest, the person arrested can be detained indefinitely until his case is decided by the court or he post a bail for his temporary release. Kung ang paghuli ay ginawa na may mandato di aresto, ang taong nahuli ay pwedeng makulong ng hindi tiyak na hanggang ang kanyang kaso ay may mapagpapiyansahan sa korte o di kaya ay siya ay magbayad ng bail para sa kanyang pansamantalang paglaya. The reason for this is that there is already a complaint or information filed against him with the court which issued the order or warrant of arrest, and it is not necessary to deliver any person thus arrested to the court. Ang rason nito ay meron ng demanded na naisampa laban sa kanya sa korte na naglabas ng mandato na de aresto at hindi kinakailangan na sampahan pa siya ng kaso sa korte. Number 5, what is the disposition of the person arrested without a warrant? In cases falling under paragraph A and B of Section 5 Rule 113, the person arrested without a warrant shall be forthwith delivered to the nearest police station or jail, and he shall be proceeded against accordance with Rule 112, Section 7, Section 5, Rule 113, Revised Rule of Criminal Procedure. Sa mga kasong pasok sa ilalim ng mga talatang A at B ng Section 5 Rule 113, ang taong hinuli na walang mandato ay kailangang dalhin kaagad sa pinakamalapit na himpilan ng pulisya o jail at siya ay ipoproseso batay sa Rule 112, Section 7, Section 5, Rule 113 Revised Rule of Criminal Procedure. Section 7 and Rule 112 of Revised Rule of Criminal Procedures state that when a person is lawfully arrested without warrant involving an offense which requires preliminary investigation, the complaint or information may be filed by prosecutor without needed as such investigation provided an inquest has been conducted in accordance with existing rules. In the absence or unavailability of a request prosecutor, the complaint may be filed by the offender party or peace officer directly with the proper court or basis of the affidavit of the offender party and the arresting officer or person. Kung ang isang tao ay legal na nahuli na walang mandato kaugnay ng isang krimen na nangangailangan ng preliminary investigation, ang reklamo ay pwedeng isampa sa pamamagitan ng prosecutor na walang kailangan ng gayong investigasyon, pero dapat may inquest na ginawa batay sa umiiral na rules. Kung walang prosecutor na magsasagawa ng inquest, ang reklamo ay pwedeng isampa sa pamamagitan ng naagrabyadong tao na alagad ng batas diretso sa akmang korte base sa affidavit ng naagrabyadong tao o sa humihiling opisyal o tao. What is the meaning of phrase shall fail to deliver such person to the proper judicial authority? It will be noted that what constitutes a violation of Article 125 is a failure to deliver the person arrested to the proper judicial authority within period of specific therein. Ang ating matatandaan na ang paglabag sa Article 125 ay bigong may sampa ng kaso sa akmang korte sa loob ng Senado nito. When do we say that the offender of a detaining officer is complied with? With the duty of detaining officer deems complied with upon the filing of the complaint the judicial authority. Ang tungkulin ng nagkulong na alagad ng batas ay masasabing natupad na sa pamamagitan ng pagsampa ng reklamo sa korte. What is the meaning of the phrase proper judicial authorities? The term judicial authorities as issued in Article 125 means that the courts of justice or judges of said courts vested with judicial power to order the temporary detention or confinement of a person charged with having committed public offense, that is the Supreme Court and such inferior courts as may be established by law. Section 1, Article 8 of the 1987 Constitution. Ang terminong judicial authorities na ginamit sa Article 125 ay nangangahulugan ng Korte ng Hustisya o huwes na nabanggit na mga korte na pinagkalooban ng kapangyarihan na nauukol sa korte na mag-utos sa pansamantalang pagkakulong ng tao sa pinaparatangan na nakakagawa ng krimen. Iyan ay ang Korte Suprema at mga korteng nasa ilalim nito. What if the judge is not available? What should be done with a detained person? Where the judge is not available, the arresting officer is duty bound to release a detained person. If the maximum hours for detention provided under Article 125 of the Revised Penal Code has already expired, failure to cause the release may result in an offense under Article 125. Kung walang huwes, ang humuhuling alagad ng batas ay may tungkulin na palayain ang nakakulong na tao kung ang pinakamataas na oras para sa pagkakulong ay ayon sa Article 125 ng Revised Penal Code ay natapos na. Bigong mapalaya ang tao na nagresulta ng isang krimen sa ilalim ng Article 125. What is the procedure to follow if the arrested person, by virtue of arrest without warrant, asks for preliminary investigation? Before the complaint information is filed, the person arrested may ask for preliminary investigation in accordance with the rule, but he must sign a waiver of the provision of Article 125 of Revised Penal Code as amended in the presence of his counsel. Notwithstanding with the waiver, he may apply for bail and investigation must be terminated within 15 days from inception. Section 7 Part 2 Rule 112 Revised Rules of Criminal Procedure. Bago ang reklamo ay isampa, ang hinuling tao ay pwedeng humingi ng preliminary investigation alinsunod sa rule. Pero kailangan niyang pumirma sa waiver sa provisions ng Article 125 ng Revised Penal Code as amended sa presensya ng kanyang abogado. Kahit na may waiver na, pwede pa rin siyang mag-apply ng bail. At ang investigasyon ay kailangang matapos sa loob ng 15 araw mula noong sinimulan ito. Section 7 Part 2 Rule 112 Revised Rules of Criminal Procedure.